Good morning, all, and thanks for joining us for the November 2018 installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these monthly as a quick update on timely issues in environmental law. I'm Ann Navaro, and along with my colleague Ryan Eletto, we're here today to discuss the recently released Fall 2018 Unified Regulatory and Deregulatory Agenda, especially as it pertains to potential changes in the energy, environment, and natural resources sector. Seems a particularly timely topic given today's the big election day. We're going to try to cover these agenda items in the next 30 minutes. We've selected topics of particular interest as opposed to giving more of a comprehensive overview. Several of these items will be addressed in greater depth at our seminar next week on Tuesday the 13th in Houston. And we hope you're planning to join us for that as well. If you have questions as we go through this, please type them into the comment box on your screen, and we will get to as many questions as we can at the end of the webinar. If we run out of time, we'd be happy to follow up on those questions in an email with you afterwards. So turning to the first slide, as I mentioned, we're going to do kind of an overview of the Fall 2018 regulatory plan from all the federal agencies and the unified agenda of regulatory and deregulatory actions. This continues to be a priority of the Trump administration in order to foster economic growth. Each agency's regulatory plan, which is a narrative text document, is a statement of their regulatory goals. The unified agenda then details specific actions that the agency intends to take, and both give a forecast of the agency's policy goals in terms of their regulatory priorities. This next slide, slide 2, is an example of what the unified agenda looks like if you go to the website. The agenda is compiled and administered by the Office of Management and Budget, or OMB, within the Executive Office of the President. Within OMB, it's run by the Office of Information and Regulatory Affairs, or OIRA. OIRA is actually quite a demanding steward of the regulatory process. It uses its review function to facilitate consistent application of presidential priorities, legal interpretation, and regulatory policy. And if the agency wants to pursue something that's not already on the agenda, it has to go through a process and get a specific waiver from OIRA and OMB. Turning to the next slide, the unified agenda is an important tool to track the administration's success in eliminating regulations and offsetting regulatory costs. It's also an important tool for regulated industry to use to understand potential changes that will impact business. In 2017, the President issued Executive Order 13771, which required agencies to repeal 2 regulations for every one they wanted to issue. According to OIRA, the rate of deregulatory reform has actually been 4-to-1, not 2-to-1, and has saved some $23 billion in overall regulatory costs across the government. I want to focus on a few potential regulatory changes that are particularly significant in the environmental and natural resource space, and that will all result in a high degree of controversy, potential uncertainty, and likely litigation. And those are potential changes at the White House Council on Environmental Quality and at the Department of the Interior. The Council on Environmental Quality, or CEQ, doesn't issue a lot of regulations because it has a very limited function, but when it does do so, it's going to be significant. In contrast, the Department of the Interior, which, as you all know, is comprised of many different bureaus, takes dozens of regulatory actions in every given year across the spectrum, from royalty rate actions at the Bureau of Land Management to civil penalty inflation adjustments for outer continental shelf operations, for regulations intended to promote the use of open science in the regulatory system. So first, I want to talk briefly about potential regulations from CEQ. And these regulations would be intended to revise the implementation of the National Environmental Policy Act, or NEPA. Revision of these regulations would be incredibly significant. The rules were issued in 1978. There was one minor amendment in 1986, and they have never been comprehensively revised. As you all know, NEPA and its implementing regulations apply to nearly every federal action the government takes. Every approval, every permit decision, every funding decision, every right-of-way grant, every land use plan, anything you can think of. NEPA governs the process, the nature of the analysis, the public engagement, and the way agencies make decisions. So revisions of the regulations implementing NEPA have serious implications for the private sector. They may improve or streamline government decision-making, and they may change information needs with respect to what's required from industry to process various applications or proposals. For sure, revision of the NEPA regs will engender new kinds of litigation to not only test the new regulations, but also to determine how they apply in specific factual situations. CEQ has taken public comment as to what proposed changes might look like, and we anticipate that they will issue a notice of proposed rulemaking as soon as early 2019. In terms of what substantively they might contain, I would predict the regulations will suggest more specificity on what is required in an environmental assessment process, which currently is the most common NEPA compliance document used by the federal government, but the regulations don't define exactly what it should contain. I would expect CEQ to attempt to refine the definitions of cumulative and indirect effects, which have to be considered in assessing proposed federal actions, but which currently have no clear sideboards in terms of causation and foreseeability in the regulations. Turning to proposed regulations from the Department of the Interior, the Department of the Interior, together with the Department of Commerce and the National Marine Fisheries Service, have already issued 3 proposals to revise various regulations that implement the Endangered Species Act. This is also incredibly significant. There's been no comprehensive revisions to the regulations since 1986, and any revision is likely to result in significant controversy and litigation. Right now, both the agencies have issued proposed rules that were issued earlier this year and taken extensive public comment. We expect that they will be issuing final regulations relatively soon, possibly before the end of this year, certainly no later than early next. And the proposed regulations address the implementation of 2 sections of the Endangered Species Act, Sections 4 and Section 7. Both sections are critical to the process of getting federal approvals or permits and to actions on private land that may impact protected species. I'm going to briefly go over these, but we will also discuss these potential changes in more detail at Bracewell's Fall Environmental Seminar next week on November 13th in Houston. If you aren't registered for that and would like to attend, please let us know. Just as an aside, the seminar will feature Mandy Gunasekera, who's the Principal Deputy Assistant Administrator at EPA's Office of Air and Radiation, who will join the air panel with our partner, Jeff Homestead. So in terms of the ESA revisions, first I just want to talk briefly about Section 7. Section 7 of the ESA sets requirements for federal agency cooperation and consultation procedures. So as I'm sure a lot of you know, if a federal agency is proposing to take an action that may impact protected species or critical habitat, they have to ensure that their action is not likely to jeopardize the continued existence of endangered or threatened species or result in destruction or adverse modification of critical habitat for such species. So Interior and the National Marine Fisheries Service have proposed a variety of changes. There's some what I would regard as somewhat easy changes. The agencies would like to define programmatic consultation, which could streamline the consultation process so that a whole category of relatively insignificant actions can proceed without a site-specific consultation. They'd like to define better what's required to start a formal consultation process so that the agencies and a private applicant know exactly what's required up front instead of having a lot of back and forth about sufficient information. In the harder category, in terms of a proposed revision that I'm not sure how it's going to look in the final rule, is with respect to mitigation. The agencies have proposed allowing other federal agencies in the consultation process to consider mitigation, but not to require that it be absolutely certain to be successful or that it be based on binding commitments, but that agencies consider it reasonably in the process going forward. That's been very controversial in the comments. Then in terms of Section 4 of the Endangered Species Act and potential changes, Section 4, of course, addresses how you add or remove threatened and endangered species from the list, procedures for designating critical habitat for those species, and it also addresses how you protect threatened species. Section 4 proposed changes, there are also a number of those, of particular interest. The agencies are proposing a change to an Obama administration rule that allowed designation of unoccupied habitat, even if occupied habitat was not being designated as critical habitat. So there was a lot of controversy around that because folks thought putting that kind of designation on land that an endangered or threatened species didn't currently use made no sense if you weren't at the same time protecting all of its currently occupied habitat. So this administration has proposed changing that rule back to require designation of occupied habitat before unoccupied habitat. This administration has also proposed identifying the economic impact of listing decisions. This is significant and has been very controversial in the comments because the Endangered Species Act itself allows the agency only to consider scientific or biological information in a listing decision. The agencies have said in their rule that they're not proposing that economic impact would be a basis for a listing decision, only that it would provide information to the public to be aware of the impact of the rules. Again, I'm not sure how that's going to play out in the final rulemaking, as that's a very controversial suggestion. Moving on just very briefly to the Migratory Bird Treaty Act. As you all may know, for many years, the government interpreted the Migratory Bird Treaty Act as acting as a criminal prohibition on both the direct take of birds, hunting, for example, and the indirect take of birds, for example, birds dying as a result of the operation of wind turbines. The new administration in late 2017 withdrew that earlier government opinion and narrowed its interpretation of the Migratory Bird Treaty Act to prohibit only the direct take of birds. This is significant for industries where incidental bird kills and the lack of a permit process to allow them was a challenge. Interior in the Unified Agenda has indicated that it may issue a proposed rule to codify that new interpretation and provide additional guidance to the field as to the difference between indirect and direct take. So moving on from kind of the natural resource area to talk about some planned actions from the Environmental Protection Agency, I'm going to talk briefly about a couple of potential actions from EPA under Section 404 of the Clean Water Act. As I'm sure you all know, Section 404 of the Clean Water Act allows the Environmental Protection Agency and the Army Corps of Engineers to regulate discharges into waters of the United States. The definition of waters of the United States under Section 404 has long been controversial and subject to extensive litigation to include a number of cases at the Supreme Court. In 2015, the last administration promulgated a rule providing a new definition of waters of the United States, which was construed as significantly expanding the agency's geographic jurisdiction. The new administration came in intending to repeal that 2015 rule to re-implement the pre-existing definition of waters of the United States and then propose a new and narrower definition of waters of the United States. That plan has been somewhat interrupted by extensive litigation. Currently, the Obama administration rule is in effect in 22 states, and the pre-2015 rule is in effect elsewhere. We expect that quite soon, this administration will issue a notice of proposed rulemaking offering a new definition of waters of the United States that will probably narrow the agency's geographic jurisdiction in line with the Supreme Court's most recent opinion on that subject in Justice Scalia's part of that opinion in Rapanos versus the United States. I expect that that will be quite a significant rulemaking that will engender a lot of public discussion and controversy that will have significant implications for the private sector, and the litigation, I'm sure, will continue for a number of years. The EPA has also proposed amending its regulations to implement Section 404C of the Clean Water Act. It's a rarely used but very controversial authority that allows EPA to essentially veto Corps of Engineers permits for dredge or fill of waters of the United States. It's been criticized as leaving a lot of uncertainty in the regulatory process. So assuming the EPA pursues that rulemaking, I would expect them to try to put some sideboards on that process to preserve their authority, but to try to provide some additional certainty for the regulated entities. With that, I'm going to hand it off to Ryan Eletto.
Thanks, Anne. Over the next few minutes, I will pick up where Anne left off by speaking about 4 EPA-related items for the unified agenda, those being the ACE rule, the CO2 for new sources rule, the oil and gas methane rule, and the SAFE rule. So first up in that list is the Affordable Clean Energy Rule, better known as ACE. This is the rule that has been proposed to replace the Clean Power Plan. The CPP was enacted in 2015 to regulate greenhouse gases from existing power plants that run on fossil fuels, but it was never went into effect because it was challenged in court immediately after its passage, and the Supreme Court stayed the case in early 2016, pending the outcome in lower courts. So a few quick similarities and differences between the ACE rule and the CPP. Like the CPP, the ACE rule would establish guidelines for states to develop state implementation plans, commonly known as SIPs, to reduce carbon emissions from existing power plants that run on fossil fuels. But an important distinction is that unlike the CPP, the ACE rule does not prescribe standards of performance. Rather, the proposed ACE rule provides a broad array of heat reduction improvement technologies, HRIs, that states can pick from in developing their SIPs, thus allowing the states to have some influence in determining their best system of emissions reductions, known as BESR. Also, unlike the CPP, which interpreted BESR as extending beyond the fence line, the ACE rule limits emissions reduction measures to on-site HRIs. And unlike the CPP, the ACE rule would allow states to consider a plant's age and remaining useful life in evaluating how a given technology would affect an individual plant. One other difference of note is that unlike the CPP, the proposed ACE rule does not appear to establish a timeline for the projected emissions reductions. Those in favor of the rule generally argue that it fits within EPA's regulatory authority, and those who oppose it contend it does not go far enough to reduce GHGs. Finally, NSR reforms are proposed to be implemented with the ACE rule, and if finalized, these reforms could be significant for existing power generators. In addition, these reforms may eventually be split out from the ACE rulemaking altogether, which could present an opportunity for other industry sectors to seek NSR reforms similar to those currently proposed for the power sector. The government's indicated that it anticipates issuing a final version of the ACE rule in March 2019. Next up, we'll discuss a rule that we'll refer to as the CO2 Standards for New Sources rule. Limited information is available about this one because the draft notice of proposed rulemaking is currently at OMB as of September of this year, but EPA has indicated that it expects to sign a proposed new rule by December. This is, in certain ways, the sister rule to the ACE rule in the sense that the CO2 for New Sources rule governs new emission sources from fossil fuel-fired power plants, whereas the ACE rule would regulate existing sources. Pursuant to EPA's authority to issue new source performance standards, NSPS, EPA has for many years regulated new fossil fuel-fired power plants to limit certain air pollutants other than carbon dioxide, which included particulate matter, nitrogen oxide, and sulfur dioxide. In the previous administration's CO2 for new sources rule that was finalized in October 2015, they determined that the best system of emission reduction, BESR, for new coal-fired plants included the use of carbon capture and storage, known as CCS technology. Critics of this technology argue that it's a de facto ban on new coal-fired power plants because there's no current economic means for obtaining and implementing that technology. 24 states and other parties sought judicial review of the rule in the U.S. Court of Appeals for the District of Columbia in a consolidated case titled State of North Dakota v. EPA. Oral argument in the D.C. Circuit was initially scheduled for April 2017, but instead the case was held in abeyance for EPA to review and consider the rule. There's a possibility that the CO2 for new sources rule will substantially change CO2 standards for new coal-fired power plants, but we'll have a better sense of that in December when the government issues that NPRM for the rule. Next, we'll discuss the oil and gas methane rule. This action proposes amendments to new source performance standards for the oil and gas source category based on reconsideration of those NSPS standards. By way of quick background, in June 2016, EPA published a final rule that established NSPS for greenhouse gas emissions by placing limitations on methane and volatile organic compounds, VOCs, from the oil and natural gas sector. The merits of that 2016 final rule are subject to litigation in a DC Circuit case called API versus EPA, but that case has been held in abeyance since May 2017. Following promulgation of that 2016 NSPS final rule, EPA received petitions for recon of certain provisions of that rule, including fugitive emissions requirements, well site pneumatic pump standards, the requirements for certification of closed vent systems by a professional engineer, and EPA granted recon on all three of those topics. Then in September of this year, EPA proposed to amend and clarify certain aspects of the fugitive emissions requirements, including monitoring frequency, low production wells, incorporating emerging technologies and state programs in the alternative means of emissions limitations. In October, that proposal was issued in the Federal Register, and comments must be received by December 17th of this year. The government anticipates that the final oil and gas methane rule will be issued in April 2017. Last in our list of EPA agenda items is the SAFE rule, the Safer, Affordable, Fuel-Efficient Vehicles rule. This rule applies to passenger cars and light trucks in model years 2021 to 2026. Two agencies teamed up on the August 2018 proposal of this rule, those being the National Highway Traffic Safety Administration and EPA. If finalized, the SAFE rule would amend certain existing corporate average fuel economy standards, commonly referred to as CAFE standards, and tailpipe carbon dioxide emission standards. In the proposed rule, EPA stated that its preferred course of action is to retain the model year 2020 standards through model year 2026, but EPA sought comment on a range of alternatives. That comment period ended this October, and the government anticipates the final rule this coming March. One aspect of the SAFE rule that has been a source of controversy is the issue of whether California can retain its authority to enact more stringent automobile GHG emission standards than the federal standards. EPA granted this so-called waiver authority to California in 2013, and a number of states subsequently adopted California's standards. But if passed, this SAFE rule proposal would withdraw California's waiver authority. Supporters of withdrawing that authority have argued that states cannot adopt or enforce tailpipe GHG emission standards when such standards relate to fuel economy because those standards are preempted under the Energy Policy and Conservation Act. While opponents of withdrawing California's waiver authority contend that EPA does not need to revoke that authority because California currently allows compliance with the federal standards to comply with California's own requirements. One potential concern in the auto industry is that if California at some point does invoke its waiver authority, auto manufacturers may then have to build California-specific versions of their vehicles in addition to the current versions. The government anticipates that the final SAFE rule will be issued in March 2019.
All right. Are we all set? Thank you, Ryan.
That is all. With that, we are done with the EPA-related unified agenda items, and we are bringing our webinar to a close.
Yeah, I think we're out of time for today, and so we will let you all get back to work, and we really appreciate your taking the time to join us. And feel free to reach out if you have any questions or want to discuss anything we talked about. Thanks.